I think this is the first non-lawyer that we have had on this program in the 5 years plus maybe now that I've been coming to this conference. But the nature of what this guy is doing, I think, is going to be of a lot of interest to you folks in the audience. I think probably to people in the office back in Brooklyn. Well, you're going to want to listen to this one. And certainly I know if Kelly is listening today, she's going to want to hear this as well. But I said if. I don't know. But if she is, now you're going to hear it, Michael.
Nice.
For that crack.
It wasn't a crack. It was a legit question.
Okay. So I don't know. I don't know.
Okay, all right.
Kelly's listening right now. All right, so sitting with me right now is Jared Johnson, and I met him at this conference, one of the few people I've met at the conference, not at the blackjack table. So Jared came up, and I guess you've listened to Ring of Fire radio in the past, but tell us what you're doing. What you're doing here. What is your entity?
Well, so I've been affected personally by debt collectors when I wasn't making any money, when I was newly married, when I was just a young entrepreneur trying to feed my family. And so when I got into working, some marketing for attorneys, a group of those attorneys sued debt collectors, and I was introduced to this vertical, this practice of suing debt collectors through getting help with actual debt collectors in my own personal life. And lo and behold, stumbled on what I felt was a missed opportunity in the United States to help consumers and give them some sort of light on a hill to get help if a debt collector is actually bothering them or doing something they shouldn't be doing. And today that's a violation, any violation of the Fair Debt Collection Practices Act, violation of the Telephone Consumer Protection Act, or Fair Credit Reporting Act violations. And so
now there's a lot of statutory protection
there is
for people who have debt, but there also seems to be a very deep and broad lack of awareness of those protections. And so what happens is the debt collectors, they run roughshod.
They prey on people's ignorance and lack of education on the subject, because so many people, we run an ad on Twitter right now that actually says, has any debt collector called you, and the call may be illegal. And what we're saying by that is, if a debt collector calls your phone without written permission in advance, using an automated telephone dialing system, the debt collector is actually obligated to pay you a $500 fine for every single call that violates the Telephone Consumer Protection Act. Nobody knows this.
So, all right, let's back up. Tell your personal story, on how you got to this. So you're working in some marketing, which, a lot of the vendors here, they help lawyers sort of advertise that they're covering a mesothelioma case or something like that. So you're around lawyers, and it's making you a little bit more savvy maybe to your rights in these instances.
It is.
And then what happens? Your wife, right?
Yeah, my wife was getting phone calls on her cell phone from a mystery number, and we decided to answer it one night. We were just doing the marital thing where the people sit in their beds and read their iPhones these days. This is what they do, So we were sitting there, and then her phone rang, and then my phone rang, and she didn't answer it. I did, and it was a debt collector. And so the guy introduced himself. He said he was looking for my wife. I asked him what it was about. He said he's trying to collect the debt. I said, well, look, I'm her husband, so tell you what, if you can send me your fax number, I'd like to send you some information myself. And what I meant by that was, I'm going to send him now a debt validation request pursuant to 1692, Title 15, that actually forces the debt collector to validate and prove that the debt is a true debt before attempting to collect the debt any further. So it's a little...
Okay, so let me just first ask you this.
Yes.
everything seems normal to me. You're sitting in bed reading your iPhones.
Yes.
But how did you know that there was a statute 1692 about validating your debt?
This I actually knew on my own even before I ever got into this, just by reading on the internet, like, things you should do if a debt collector calls you, and like the cowboys of, doing this kind of thing. This is one of the only things they know. So they talk about this first, and you Google it, and you see all these like templates people have written that you.
So
can
if you
just
don't have a
sign
fax machine, can you email
you
it?
Just send it in the mail.
Oh, the physical
Yeah,
mail.
Physical mail.
And what is it you write on this?
So the debt validation notice just says, I'm requesting that you prove that the debt is a valid debt, and that as a debt collector you have the right to collect the debt in my state, that you are bonded and licensed, that that the debt itself hasn't lost any chain of ownership. So for instance, if they're collecting on a debt that they don't actually even own or never bought, well then they can't really collect the debt, can they? So I want to prove that, and so we want to show that where did I sign anything? Do you have a physical contract signature that shows that I agreed to take this debt out? I actually truly owe this debt at all. And so you're asking them to prove that you really owe what they are attempting to collect. If they cannot prove this, they cannot continue collecting it. If they don't attempt to validate the debt, they don't send you anything back, they cannot continue to collect the debt.
They can't call you, they can't write you?
It's a Mexican standoff. You're done right then and there, and I've sent letters out to literally watch it all vanish. This disappears off my credit report, never get a phone call, they just walk away and never call you again. And in some cases, it can stay in your credit report, but they won't collect it.
Interesting.
They just leave you alone.
Okay, so you went through this, and then you're thinking, not many people realize this.
No, not many people realize this, and even in the letter I sent them, there's two things. I want to ask for a validation of debt. I also want to revoke consent. So I don't want them to call my mobile phone anymore. So inside the letter, I actually say, please don't call my mobile phone anymore. That's revoking consent. You probably gave consent to the original creditor when you took the loan out, giving them permission to call your mobile phone using an automated telephone dialing system, but you can take that back at any time. Just by saying, I don't want you to call me anymore, I'd rather do this via the mail. So when you've done that, you revoke consent. Now, anytime they call you after that, it becomes a violation of the Telephone Consumer Protection Act. So you bet, I sent that debt validation letter off to this debt collector. They got it in a fax the next morning. That same night, they called my wife's phone, my phone, and continued to try and collect the debt. So the first call to my wife's phone is a $500 fine. The call to my phone is another $500 fine, because I'm also, and the fact is they called my phone and I'm not even listed on the debt. So I personally never granted this entity any consent to call my phone. So my wife may have, but I certainly had never. Then the attempt to continue to collect the debt violates 1692. I'm not sure which letter on that statute it violates, to continue collecting prior to validation of the debt. So there's 3. And then they actually used, some pretty bad language, things like harassing language. You can't use profanity on the phone. That's a 4th one. So they did all this. I said, look, man, see you later. Hung up on them, and had a fantastic attorney. His name is Craig Ehrlich. He's in Atlanta, Georgia. He called them up, and in about a week, he had it all settled out. He said, the debt's gone. We're going to pay your wife $500 just for her trouble. They're going to agree to my attorney's fees. Is that acceptable to you? And we're like, yes. So for all that, in a matter of just a few weeks, we had an extra $500 cash. But it made me think about this, like, well, why isn't there one big, helpful brand that's out there that people can give their information to and then get free attorney. So, because that's the thing with sue the collector, all the attorney work is absolutely for free for the consumer because the attorney never charges the consumer. It's not like a car accident attorney where the attorney gets 30% of whatever's recovered. The attorney gets none of this money. The consumer gets everything that's recovered, and the attorney actually gets to bill their time and expenses to the debt collector, and federal judges enforce the attorney fee provision and collect that money on the side, separate from all the other money that they actually sued and won.
And it doesn't come out of what is owed to the consumer, because what's owed to the consumer is a statutory amount. There's you're not doing like damages on like this has caused me mental anguish.
It does, no, that's so. You get, like, for instance, with the FDCPA violation, it's a $1,000 statutory award plus actual and punitive damages.
Wow.
So this gets to be a lot bigger if you can show mental anguish, if you can show that this has affected your ability to buy a house you were about to close on in 2 weeks, but this jerk-off collection agency just put this bad thing on your credit report, and now you can't, now they're going, well, you got to get that off or you can't close. And so now you're like stuck in a motel for 3 months and all these outgoing expenses, and maybe you don't get the job you were looking for because people do background checks and stuff like that. You got bad credit, you can't get a job. And so there's all these things. And so if it's all illegal or wrong, you can prove actual damages that way.
Okay, so there was one of the things I asked you earlier as when we were talking is if there's been any change with the Trump administration. And I was thinking about Betsy DeVos because she seems to have unshackled the student debt collectors in many respects. Has there been any implications of that? A, and then B, more broadly, what are the implications of the Trump administration on debt collection?
Now, I'm a non-attorney, so I'm going to just talk about what I know. So I know that the nomination and confirmation of Judge Gorsuch to the Supreme Court, Judge Gorsuch actually wrote a recent opinion regarding debt buyers, third-party debt buyers. There was a case against Santander USA where it was pending before the Supreme Court. Judge Gorsuch got in, so then he got to actually write the majority opinion on it. They voted that third-party debt buyers should inherit the rights of original creditors. The reason why this is important is because the Fair Debt Collection Practices Act does not apply to original creditors. So when these third-party debt buyers are now considered original creditors again, they can continue harassing, even though they never loaned the money out themselves, even if they buy the debt at 5-10 cents on the dollar. They really don't have any actual monetary interest in the debt, really, except for now they've suddenly...
Except for as a commodity, because they were never involved in the original transaction.
But there's a catch. So like anything, this is a weird decision that isn't all by itself bad in some way. It is bad, as it was fine the way it was. But what it has done is if Santander decides to now collect debt for itself, for its own debts, they can actually remove that protection, because then they can be ruled as a third-party debt collector again, because if they statutorily fall under that definition, then it can be made, an argument can be made. But then if they don't want to do that, they just want to hire somebody else to collect it, a law firm.
Right.
The law firm would then be subject to the Fair Debt Collection Practices Act. So it just passes that roll down one chain.
With that said, I mean, so just so people understand what Gorsuch was trying to do here, and the conservative majority on the court was basically saying, okay, it is the law that all red dogs must be on a leash. And then they just looked at some dogs and said, well, they're not really red. They're more like maroon.
Right.
And
exactly.
so we've just redefined what red means.
Right.
Red, if they don't have red hair and red eyes, they're not red.
Right.
Okay, and I just, we got a saying for that around here, and that is the moon just fell into Lake Michigan again. you don't necessarily need to know what that
No.
means. But okay, so and what about on the DeVos end? Is there anything that's happening there? I know that she has severed the relationship with the Consumer Financial Protection Bureau to sort of oversee these debt collectors. Are you anticipating more problems on that accord, or is there any way to know?
So at the granular level, student debt, if collected by a third-party debt collector, is still going to be subject to the Fair Debt Collection Practices Act, regardless of it's a federally, insured loan itself. It's, they're still going to have, these third-party, actual debt, not just buyers, but the actual third-party debt collectors. They don't own the debt, but they're hired to make the phone calls. They're hired to follow up with the debtor and try and collect payments and so on. They are subject to the Fair Debt Collection Practices Act. It's still fair game to send these third-party debt collectors debt validation notices. Once you get that first letter from the debt collector that says you have 30 days to request validation, send that letter.
Okay.
Because inside of that 30 days is the statutory timeline in order to request the debt validation itself. You can still send it after 30 days, but they don't necessarily have to get back to you in any statutory amount of time either.
So, if I go to your site, Sue the Collector, will I get all this information?
Yes, you will.
So if I know that I'm getting calls from debt collectors, if I know that I'm getting calls from debt collectors or letters or whatever it is, I go to your site, I can get a bunch of information that doesn't necessarily involve beginning to sue. It just says you should take these steps first to protect yourself.
You should.
And then in the event the debt collector continues on with this behavior, then you have time to do some type of action.
Yeah, and if you don't find it, call us, because we have literally a network of attorneys that are standing on whole, in the office waiting to answer. And so you won't talk to a paralegal, you'll talk to an attorney that actually prosecutes these kind of cases, and you'll talk to them now. So if you call our toll-free number that's listed, which is 888-433-9750 at suethecollector.com, you'll get a hold of an attorney right away. Ask them anything.
And you made the point, I was like, is there any chance that this could inhibit the behavior of debt collectors? And you made the point that this is just like they're preying off the ignorance of the general public.
Yes.
And so
it's a numbers game.
It's a numbers game for them.
They know that if 5% or less, it's probably way less than that. In fact, I think Attorney Suleiman told me in his office that only 22,000 such cases were filed last year.
And there is $1 trillion worth of debt out there,
Yes.
and people know how debt collectors behave.
But only 22,000 ever got filed in federal court in this field. That's nothing. So that's why, that's proof. It's a total numbers game. So if these guys only have to fight off with, of course, their corporate liability or their errors and omissions insurance that they have. So they only have to just keep filing claims with their errors and omissions insurance. They get settlements. They close it. They start again.
Just the cost of doing business. As long as it's suethecollector.com, right?
Yes.
As long as suethecollector.com doesn't get huge and then inform everybody of the rights they have in terms of collecting, they'll continue on with these business practices.
Man, I think even if this did become huge, I don't honestly think that it's in the best monetary interest of debt buyers, debt collectors, these payday loan companies. All these guys make so much money on all these crazy loans, and the interest rates are so high. It makes no sense to start correcting that behavior today. They would have already been correcting that behavior if it made, because we've seen huge awards come out of some of the cases that have been brought before the court, wrongful foreclosures resulting in $1.2 million awards. Bank of America had to settle with this nice couple on a TCPA claim, $1.8 million. The judge awarded a treble damages verdict. So there was some almost 900 phone calls placed using an automated telephone dialing system after this couple got behind on their mortgage. The judge awarded $1,500 a call.
Wow.
$1,500 a call, almost 1,000 calls. The judge went $1,500 times this. I mean, it was just a straight up math verdict, like here. And they walked away with millions of dollars, free house, the whole 9 yards. Confidential settlement I just heard was somebody's mixed file case. So that means somebody's similar, same sounding name ended up on somebody else's credit report and drug their credit score down. $100,000 settlement. And that's the low end. That was the first offer that this company had made. They likely, if pushed, would have been $200,000 or $300,000 settlement.
Wow.
So, this isn't kids play. These cases are worth a ton of money. At the very minimum, you can get the debt likely dismissed and voided forever. At the most egregious violation, full experience, you could be awarded millions of dollars.
Wow.
And so it's worth checking it out. It's worth looking into it. If you're getting phone calls on your mobile device from a debt collector today, tell them to stop calling you. Tell them to stop. Just the next call, just say, hey, I want to do this by mail instead. I don't really want to do it over the phone anymore. If they call you after that, I want you to write down every single date and time and the number they called you and keep a call log. And then we're going to use that to sue the collector, and we're going to go get $1,500 a call for
Screenshots
you.
of your recent phone thing.
Or just print out an itemized bill from Verizon or wherever your telephone provider is. We'll get the TCPA claim going. That can be huge. I mean, and a lot of times we'll let that toll. So if we know it's going to just continue on, say, hey, give it a month or two. Let's not file right away. Let's let this behavior continue, because if we get 60, 90 calls deep into this thing, we've got a very serious claim on our hands. So let's go. Let's just wait it out. Secondly, if you see errors on your credit report and Equifax is refusing to remove completely erroneous information, that is illegal. We can help you sue Equifax, TransUnion, and Experian. And then, of course, under the FDCPA, there are a number of things, but let me tell you the one most common thing.
Okay.
Is if you see a collection agency publish something on your credit report and you do not get a paper notice within 5 working days of that initial communication, that publishing on your credit report, you have a case against the debt collector right now.
SueTheCollector.com.
SueTheCollector.com.
Jared, thank you so much. It was a real pleasure.
Man, I am
congratulations
super happy to help anybody I can. And so it's helped myself out, and I want to help everybody. So let's do it.
All right, thanks. Thank you for stopping by.
Hi, folks. Sam Seder here. We still need your help on our Patreon page. YouTube ads have come back, but not nearly as much as we had before. So if you can help us out, any little bit helps. Head over to our Patreon page right at this URL, and you'll help us keep helping you by making videos